Welcome to the Melling Law YouTube channel, where we provide Utah-specific information about estate planning, probate, and asset protection. In Utah, almost every state estate plan uses two standard forms in addition to the planning documents like wills and trusts. Each of these forms names a person that can make decisions on your behalf if you become incapacitated due to an injury or illness. One form is called a power of attorney and designates someone to manage your financial affairs when you are not capable of managing them yourself. We will discuss powers of attorney in another video. The second form, which we are discussing today, is called an advance healthcare directive. Instead of appointing an agent to manage your finances, this form allows you to appoint an agent to make your healthcare decisions. Sometimes this form is referred to as a living will or healthcare power of attorney. The Utah State Legislature decided that the Advanced Healthcare Directive was so important that it standardized this form to make it easier to use and define the agent's powers. What you see here is the beginning of the Utah Advanced Healthcare Directive form. As you can see, it's divided into four parts. Part 1 appoints a healthcare decision-making agent in the event that you cannot make healthcare decisions for yourself, or if you are physically unable to make your wishes known. Part 2 allows you to make a written statement about your wishes. Part 3 gives you instructions regarding revocation or alteration of the form. And finally, Part 4 tells you how to make sure your form has a binding legal effect. Choosing an agent in Part 1 is by far the most important part of the form. In my conversations with healthcare workers in Utah, the general consensus is that a hospital or healthcare facility will not make any important decisions based on your written healthcare wishes. However, they will honor the appointment of your agent and defer to the agent's judgment if needed. The written healthcare preferences, other than the agent's appointment, only come under consideration if there is a dispute between family members that ends up going to court. Therefore, the appointment of an agent is the single most important part of this form. If you do not fill out this form, the order in which an attending healthcare facility would look for someone to make decisions on your behalf is as follows: spouse, then the first child readily available. If no child, then the first parent readily available, and then siblings, grandchildren, and grandparents. If you do not like that order, then the agent designation is especially important to you. You must keep this agent information up to date, as a facility with the document on file will look to the form first to contact family members. The form allows you to choose an alternate agent in case your first agent is unavailable or unwilling to serve. Many people will choose a spouse as a primary agent, then choose an alternate agent in case they and their spouse are in an accident together. As you can see here, the agent's authority is extensive and outlined within the form. You will want to read over these powers carefully to make sure you are okay with the agent having all of those powers. Under Other Authority, there are a couple of additional powers which I usually recommend people granting to the agent. The last thing you want is for your agent to be restricted because of some privacy or federal regulation. If you do not trust your agent completely, this is probably not the form for you anyway. Now, one purpose of this form is to help avoid the need of a guardianship, as they can be costly and require more court oversight than you would prefer. Sometimes, however, this form will not be enough, and a court may still require court oversight through guardianship. If that is the case, this subsection G here allows you to state whether you want to nominate your agent as the court's first choice for a guardian. The court would still need to approve the agent, but they become the court's first consideration if nominated in this form. Subsections H and I grant the agent more powers regarding clinical trials and organ donation. Once again, I normally recommend granting the agent as much authority as possible to avoid legal entanglements. However, if you do not trust your agent completely, then you may not want to grant the agent these powers, or any powers for that matter. Part 2 of this form is called the living will component. It allows you to state your healthcare preferences in writing. Once again, I normally recommend leaving all decisions to the agent as stated in option 1. That being said, some people may not want to appoint an agent, simply wish to record their wishes in writing. Many healthcare facilities will take such wishes into consideration, but ultimately defer to a designated or court-appointed agent or family member. Option 2 is an interesting choice and allows for some physician judgment. It allows you to state that you wish to prolong your life regardless of your condition or prognosis, including a persistent vegetative state. However, it does limit that prolonged care to the limits of generally accepted healthcare standards. If you want to find out more about what happens when physicians are instructed to prolong life beyond those limits, you can find plenty of horror stories online. Option 3 allows a little more customization in your wishes. This option is for those who wish to receive only comfort care under certain conditions. These conditions can be determined by the agent or chosen by yourself. Option 3A defers the decision to quote-unquote pull the plug to your agent, while option 3B allows you to define the circumstances under which you would want to be removed from life support, including progressive terminal illnesses, unlikely recovery from near-death conditions, inability to communicate, and persistent vegetative states. Once again, a hospital will not likely pull the plug without consulting with a designated or court-appointed agent or family member, so you may be best served by leaving everything up to your agent anyway. Personally, I'm the type of person that would choose all of the options under 3B. However, I'm not all-knowing and I never will be, therefore I choose option 1 and leave everything to the agent. I trust both my agent and alternative agent, and I've discussed my values with them. I know that they will honor my wishes, but also consult with physicians so they can fully incorporate my wishes with the judgment and advice of healthcare professionals. If I did not trust them to know my values and implement them, then perhaps 3B would be the best choice, but it's a matter of personal preference. Option 4 allows you to omit the expression of your preferences. This is generally used for those who simply want to appoint an agent but do not want to state their healthcare preferences. Please note that at the end of Part 2, it states that you need to work through a physician or other approved healthcare professional to complete a Department of Health form regarding withholding of CPR or other life-sustaining treatment in the event of an emergency. Part 3 gives detailed instructions regarding how to revoke or change the directive. I generally recommend performing options 1 and 4 together, so you would destroy your first document and write a new one. To make sure the new form is effective, it's best practice to notify your agents, family care physician, and hospital. I know that Intermountain Healthcare will let you submit your directive for their database, since it's fairly useless for your doctor if the directive is in your safe at home. Part 4 gives great instructions to make sure the document is binding. This part is completely self-explanatory and lists the limitations on the witness that would exclude them from serving as a proper witness. I generally recommend finding a notary that meets the criteria listed in the form, but that's merely a formality and it's not a requirement. And there you have it. You now understand some of the basic issues associated with a Utah Advanced Healthcare Directive. You can fill it out yourself, but many attorneys include it in their estate planning packages because after the discovery meeting, an attorney can help make suggestions for an effective healthcare directive based on your age, family dynamic, and overall estate plan. If you have any questions about this form, feel free to discuss them with your primary care provider and your estate planning attorney. Please subscribe to our channel for more updates on Utah-specific estate planning matters. You can always reach us here at Melling Law at 435-572-0807 for a free initial consultation regarding your estate plan.